Good afternoon, everyone. Thank you for joining us for the next in the series of a Beale Company construction law update. Many of you will be aware of the format of these webinars now. Today we are discussing limits of liability and exclusion clauses in consultants' appointments in the UK construction and engineering market. This, of course, is a well-versed subject. The intention of today's webinar is to approach things a bit differently. We're going to discuss some relevant and recent case law. However, we will also look at what the industry standard agreements and the market are doing in relation to limits of liability and exclusion clauses. My name is Will Buckby and I lead the Projects and Contracts Advisory team at Beale Company. I'm joined by Simi Sivapalan, who many of you will know. Simi's work is split across projects and contracts and dispute avoidance. During the next hour, Simi and I will be working through the agenda on this slide. The first part of the webinar will look at why limits of liability and exclusion clauses are relevant to the construction and infrastructure industry. I'm sure this will be a reminder more than anything else for most of you. We will then look at the enforceability of limits of liability and exclusion clauses with reference to some well-known cases. After that background, we're going to discuss the different types of limits of liability and exclusion clauses, discuss various standard form agreements and how they approach such clauses, and then we're going to consider what the market is doing and any trends which we can highlight. Finally, Simi is going to briefly look at how our consultant clients might approach their policies and procedures in relation to limits and exclusion clauses. And thereafter, we're going to conclude with some practical considerations. I'm now going to hand you over to Simi.
Thank you, Will. Beginning with the basics, we often use phrases such as unlimited liability, cap on liability, and limits of liability. A reminder of their relevance is useful for what follows next in this webinar. A long-established principle following the decision in Hadley v. Baxendale is that if a party is in breach of contract, the defaulting party will be liable for all losses which fall under two limbs. Firstly, losses arising naturally from the breach, and secondly, losses which are reasonably in the contemplation of both parties at the time the contract was made. Whilst the losses recoverable from a defaulting party will need to fall within the above limbs, in the absence of a financial limit of liability, such losses will be unlimited and may also exceed the limit of indemnity on the consultant's professional indemnity insurance policy. A cap on liability limits the amount of the professional consultant's liability to the client. As Will explain later in this webinar, this cap can be expressed in a number of ways. Importantly, the required level of professional indemnity insurance cover should not be confused with a cap on liability. A clause which requires the consultant to maintain professional indemnity insurance effectively requires the consultant to provide a pot of money to meet any potential claims for breach of the contract. This is different to a liability cap. A liability cap is a provision setting out the maximum amount which can be claimed from the consultant in the event of a breach of contract. It is important that the two are not confused. An obligation in an appointment to maintain professional indemnity insurance does not limit a professional's liability to the amount of cover provided by that insurance. A separate express clause is needed, agreeing that liability should be limited and the level of that limit. Whilst the inclusion of a limitation clause is important, it is equally as important to ensure that the limit of liability clause is enforceable. As a reminder, limitation clauses are enforceable under UK law, and the courts or tribunals generally enforce such provisions subject to a few exceptions and controls. The Unfair Contract Terms Act 1997, or UCTA, requires that any clause which is in a supplier standard terms or attempts to limit or exclude liability for negligence must satisfy the test of reasonableness. If it is not reasonable, the term is unenforceable. This applies to almost all limitations and exclusion clauses. Reasonableness is assessed on a contract-by-contract basis by taking into account criteria such as the bargaining positions of parties and the availability of insurance. For example, in the case of St Albans City and District Council and International Computers Limited, the court held that a limitation clause which sought to limit International Computers' damages to £100,000 was not reasonable. The court held this was because International Computer demonstrated no evidence to show that it was fair and reasonable to limit its liability under its contract to £100,000. The case highlighted that a monetary figure used in a limitation clause cannot simply be chosen at random and must be a figure that can be justified objectively. In deciding the maximum liability a consultant is prepared to accept, the consultant should assess the nature of the risks for each particular project and also the damages that could be payable if the consultant is in breach of contract or is negligent. This will include not only the cost of putting things right, but also all the other losses that could be caused to the client. An assessment would also need to be made of the damages that could flow from any particular matters, such as pollution and contamination claims. The amount of professional indemnity insurance cover is a relevant factor, but this does not mean that if the professional has, say, 5 million PI cover, the limit of liability for every appointment should also be 5 million. The monetary amount included in the limitation clause should be appropriate for the type of commission being undertaken. As I will explain in the next slide, it is not essential that a limit of liability must match the required professional indemnity insurance, which may be a greater figure. The earlier case of Moores v. Yakeley Associates considered the effect of a monetary limitation in the REBA standard conditions and held that a limit on liability of £250,000 was reasonable despite the architect maintaining insurance of a higher level. This was based on overall circumstances, namely the fees were in the order of £20,000, the cost of the works, the fact that the client was in a stronger bargaining position and had greater resources than the architect, and that the client had been aware of and had a chance to object to the clause. As well as the controls I have just mentioned, liability clauses and exclusions are subject to a few exceptions. For example, pursuant to UCTA, liability cannot be excluded or restricted for death or personal injury resulting from negligence. As a matter of public policy, liability cannot be excluded for fraud or fraudulent misrepresentation. Before handing back to Will, I will discuss the decision in the recent case of Ampleforth Abbey Trust v. Turner & Townsend Project Management Limited. This case considered the reasonableness of caps and is a reminder of the potential wide-reaching ramifications for limits of liability clauses in consultants' appointments. The relevant part of the limit of liability clause in Turner & Townsend's appointment stated that liability would be limited to the lower of Turner & Townsend's fees, which were just over £100,000, or 10 million, which was the level of professional indemnity insurance Turner & Townsend were required to take out. In this case, the court held that the cap on liability was not reasonable under UCTA and was therefore unenforceable. This was partly because of the contrast between the financial limit of liability and the level of professional indemnity insurance the consultant was required to maintain. We don't think that the judge was entirely right on this point, as consultants generally take out professional indemnity insurance to cover all of their activities for the period in question, and usually PI insurance is much higher than that revealed to the client. However, the judge held that there was no explanation as to why Turner & Townsend should have stipulated insurance cover of £10 million despite a limit of liability of a much lower sum. The judgment reinforces that a liability cap may be unreasonable if it is far below the amount of professional indemnity insurance required under the professional's appointment, in this case 10 million. It is therefore best practice for a professional consultant to draw the client's attention to any cap on liability. In any event, consultants should also ensure that any cap on liability is in line with the PI insurance. It may not always be appropriate simply to cap liability by reference to a percentage of the contract sum or the consultant's fees. I'll now hand you back to Will.
Thank you, Simi. Following that background, I'm now going to discuss the main limitation and exclusion of liability clauses, which are most likely to be considered by consultants when reviewing appointment documentation. These are financial limits of liability, exclusions for indirect and consequential loss, net contribution clauses, time limitation clauses, and clauses which seek to exclude liability for particular risks such as asbestos. There are also less common limitation clauses which I'm going to touch upon, such as the evaporation clause. So, financial limits of liability. The starting point, I think, is that consultants' appointment should limit a consultant's liability for all claims arising on a project to a given financial amount. One view is that this is perhaps the most important clause in any appointment. Agreeing a suitable financial limit of liability should give the consultant comfort as to its exposure on the particular project. There are various approaches, as you know, to such clauses. Perhaps the most common is limiting liability to an agreed financial amount, let's say 5 million, in the aggregate across the whole of the project. Other approaches include limiting liability to a financial amount on a per claim or an each and every claim basis, or to a given financial amount on an annual basis. Obviously, a financial limit of liability in the aggregate is preferred, as this would give the consultant comfort, as I say, to its total exposure. The risk of a per claim or annual limit means that a number of claims could be commenced up to the limit across the whole of the project. It goes without saying that a financial limit of liability clause should mirror the limit of indemnity of a consultant's professional indemnity insurance. Consultants should not be agreeing to financial limits of liability which expose the consultant to losses in excess of the cover available. Therefore, negotiating limits of liability clauses should go hand in hand when negotiating the limit of indemnity for the professional indemnity insurance to be maintained. This is particularly important following the Ampleforth case, which Simi's just mentioned, which demonstrates the risks as to the enforceability of a financial limit of liability if there is a significant difference between the limit of liability and the limit of indemnity. An alternative approach to a financial limit of liability clause is to limit liability to the amount of the professional indemnity insurance to be maintained by the consultant, as is stated elsewhere in the appointment. This should be fine. However, there are some risks, some minor risks with this approach. From a liability perspective, as professional indemnity insurance is usually expressed on a per claim or each and every claim basis, it means that the consultant will not achieve the aggregate financial limit of liability cap, which should be preferred. Also, and it goes without saying, that it's fundamental that the drafting of such a clause works, which in our view is not always the case. We commonly see a financial limit of liability clause stating that the amount of the aggregate limit is the professional indemnity, limit of indemnity to be maintained, but this is expressed on a per claim basis. So the two clauses effectively are not joined up. So depending on the drafting, there can be a conflict, and this does create some uncertainty. So the drafting needs to be carefully worded. Another common approach is having a financial limit of liability clause which is limited to the fee or a factor, say 10 times of the fee. Again, this is usually fine. However, this drafting also needs to be carefully couched. For example, does the reference to the fee mean the fee payable to the consultant across the whole of the project, as stated in the appointment when it is signed? Does it include variations? Moreover, does it mean the fee payable at the time of the claim or when liability arises? The amount in all these examples, the amount of the fee in all these examples could be different. The message is that the drafting needs to be clearly stated, otherwise there could be a disagreement as to what the clause means, or even the risk that the clause is unenforceable for perhaps being too uncertain. As I say, my preference is always for an aggregate limit of liability which is consistent with the professional indemnity insurance requirement in the appointment. Finally, in relation to financial limits of liability, we're seeing an increase in consultants in their standard terms and conditions seeking to achieve a one-glass limit of liability for all losses arising across a project. The limit in the standard T's and C's would seek to deal with all losses under the appointment, collateral warranties, let's say reliance letters, and in respect of negligence claims from third parties who are not the subject to any limit of liability because there is no contract with the consultant. The drafting is achieved by stating in the appointment that the consultant's liability for the whole commission is limited to a given amount and that the client indemnifies the consultant for losses over and above that amount. In addition, there's related drafting in the collateral warranties and the reliance letters acknowledging that there is one limit across the whole of the project, and also referring to the appointment. There are clear benefits to this. Our view is that such an arrangement is most likely to work. There perhaps is a risk that the limit could be unenforceable under UCTA for being unreasonable, as for example third parties could find themselves without recourse against a consultant where a cap has already been exhausted because of earlier claims. I don't think there's any case law on this issue, and obviously any such arrangement would need to be looked at on a case-by-case basis, and as always, the drafting needs to be done very carefully. Consultants' appointments, in our view, should also include an exclusion for indirect and consequential losses. This is to avoid the consultant being liable for losses which are far removed from the services being provided under the appointment. An exclusion for indirect and consequential loss, I think, is a common clause. It's also frequently negotiated between the client and the consultant. However, what does indirect and consequential loss mean? The term, I think, is commonly misunderstood, partly because consequential loss is a classic case of words not bearing the dictionary meaning in a legal context. As Simi has mentioned, under the rule in Hadley and Baxendale, a person who breaches a contract is generally liable to the innocent party for any loss that falls within one or two limbs. The first limb, and these are stated on the slide, is loss that arises naturally or according to the usual course of things from the breach. The courts often refer to this first limb as direct loss. The second limb, such as additional loss as the parties would, at the time when they made the contract, have reasonably expected to be the probable result of such a breach. The courts have generally referred to this second limb as a consequential or indirect loss. When a contractual clause excludes or limits liability for consequential loss or damage, it only excludes loss under the second limb of Hadley and Baxendale. The scope of such an exclusion may therefore be far narrower than one actually realises. In particular, the law often regards loss of profit as a direct loss and not indirect and consequential loss. And there are a few cases that demonstrate this. For example, in Pegler Limited and Wang, a 2000 case, the exclusion clause stated that the defendant shall not in any event be liable for any indirect, special or consequential loss, howsoever arising, including but not limited to loss of anticipated profits or of data. The court held that this clause did not exclude all liability for loss of profits, but only loss of profits of an indirect or consequential kind. As the claim was for direct loss of profit, the clause did not protect the defendant. Similarly, in Ferryways and Associated British Ports, a 2008 case, the clause stated that the defendant shall have no liability which is of an indirect or consequential nature, including without limitation the following loss of profit. The court held that by using the words including without limitation, the parties were identifying the type of loss that could fall within the exemption clause, so long as it met the prior requirement that the loss was of indirect or consequential nature, it would be excluded. It meant in this case that again, direct loss of profit was not therefore excluded. So it follows that if a consultant wishes to exclude liability for, say, loss of profit, this must be clearly stated in the contract. In light of these and other cases, there are several points to bear in mind when drafting exclusion clauses. Before you start drafting, clearly identify the liability that you want to exclude. For instance, are you happy with an exclusion of consequential loss only, or do you also want to exclude certain direct losses such as direct loss of profit? Consider as precisely as possible the categories of loss for which you will not be liable, such as loss of opportunity, loss of profit, loss of production, and loss of business. And be wary of words like other and including, which may have a limiting effect on an exclusion clause as demonstrated in one of the earlier cases. Use the word indirect instead of consequential to describe the loss. Commercial parties are clearly more likely to understand the clause if you do, and be alive to the other provisions of the contract, particularly those that establish liability, so that any exclusion clearly covers the likely losses. Every contract should be construed as a whole. We also recommend that net contribution clauses are included in appointment documentation. The reason for this is where a loss occurs for which two or more parties are responsible, the claimant or the party suffering the loss can sue either of the parties responsible for the full value of the loss, regardless of the extent of the responsibility. Yet this position still surprises people. In such circumstances, the liable party would be left to recover the other responsible parties, recover from the other responsible parties under the Civil Liability Contribution Act. This clearly exposes the consultant or the responsible party to the time, expense, and risk of pursuing a claim for contribution. Moreover, the consultant would also carry the insolvency risk, as no recovery will be possible if the other parties responsible are insolvent, have no assets, or obviously professional indemnity insurance. So a net contribution clause limits the consultant's liability to an amount that is fair and reasonable, taking into account the party's responsibility to the client for the loss. Net contribution clauses are common in most standard form appointments. As shown on the side, robust net contribution clauses are included in the ACE agreement and also the REBA consultant's appointment. There's also a net contribution clause in the NEC3 PSC, although as Simi is going to touch upon later, this is brief and perhaps should be amended. As with all clauses, the effectiveness of net contribution clauses depends on the clarity of the drafting. And an example of the care needed to draft such clauses is demonstrated in the case of Stephen and Carol West and Ian Finley Associates. This case concerned the interpretation of a net contribution clause in the appointment between the Wests and their architects in Finley. So the Wests appointed Finley as their architect to design and administer works to their home. The Wests appointed a main contractor and also directly appointed other specialists to design and supply certain elements of the project. Unfortunately, the works carried out by the contractor were defective and a dispute went to court where the judge decided that the architect had been in breach of its professional duties and the main contractor had been in breach of its contractual obligations to Mr. and Mrs. West. Both were therefore liable. Unfortunately, the main contractor went bust and consequently the Wests sought to recover 100% of their losses from the architects. Surprise, surprise, the architects in turn sought to rely on a net contribution clause in their appointment. This stated, and the clause is on your slide, our liability for loss or damage will be limited to the amount that is reasonable for us to pay in relation to the contractual responsibilities of other consultants, contractors and specialists appointed by you. The judge was therefore required to consider whether the clause was effective in limiting the architect's liability, where the main contractor was also liable. The judge understandably said that net contribution clause was ambiguous. However, he held that the clause did not limit the architect's liability in respect of losses incurred by the main contractor breaching its contract. It merely limited the architect's liability in respect of breaches by specialist contractors appointed by Mr. and Mrs. West outside of the main contract. Mr. and Mrs. West could therefore recover 100% of the damages from the architects who had no means of obtaining a contribution to those damages from the bust main contractor. Is that fair? Fortunately for the consultant, this decision was reversed in the Court of Appeal, but the reason I raise it and have described it in that way is because it serves to show how careful one must be when agreeing the wording of net contribution clauses. We also advise our consultant clients to include a time limitation clause in their appointments. The Limitation Act, which most of you know well, specifies the limitation periods which apply in relation to simple contracts and deeds. Under the Act, actions for breach of contract and torts such as negligence must be brought within a period of 6 years for a contract, and then 12 years if the contract is executed as a deed. These time periods begin either on the date on which the breach of contract occurred or the date the negligent act or omission occurred. The limitation period doesn't run from the date of the contract itself. Importantly, parties can agree to vary the statutory provisions, and as I'm sure most of you have experienced, it is common for liability periods to be unnecessarily extended to, say, practical completion of the project. In our view, this should be avoided. We recommend that the drafting is added to say that the time period in which claims can be made ceases upon the earlier of completion of the services, PC, termination of the appointment, or importantly, as prescribed by law. This area of the law was the subject of the Oxford Architects case in 2006. In this case, Cheltenham Ladies College employed the architects to provide services for a building of a teaching block. The appointment stated that no proceedings could be brought later than 6 years from PC, which occurred on the 25th of November 98. The college commenced proceedings on the 25th of November 2004, just within the 6-year period stated in the contract. The architects argued that the claim was statute barred under the Limitation Act because the actual breach and accrual of damage had occurred before PC, and that the proceedings were brought out of time given that more than 6 years had passed since the breach or the accrual of damage. The arbitrator held that the clause did extend the statutory limitation period, and therefore no such limitation defence could be raised. The architect appealed to the High Court, arguing that the clause did not override the statutory limitation period, but operated alongside it as a parallel contractual limit. Ramsey, the judge, agreed with the architect's interpretation, in fact, and held that in order to extend the statute limitation period, clear words would be needed such that the right to rely on limitation defences under the Act is expressly excluded. It's not enough to refer to when claims can or can't be commenced. So one of the lessons from this case is that it's important that limitation periods, whether statutory or contractual, to be considered carefully. If a limitation clause is intended to reduce the statutory limitation period, it should state, we think, the cut-off date after which claims may not be brought, and expressly refer to the statute and the rights granted under it. Now moving on to particular risks. In some cases, it can be reasonable under UCTA to exclude liability in respect of particular claims and matters, and where appropriate, consultants should do just that. The circumstances in which it would be reasonable to exclude such liability might be where it is agreed by the parties that a third party or client is to take on that risk. Common risks which are excluded include pollution and contamination risk, asbestos, and terrorism claims. One of the reasons why these risks are excluded is because some professional indemnity insurance policies do not cover claims arising out of these risks. In the recent case of Persimmon Homes and Arup, an asbestos exclusion was considered. Persimmon Homes and others formed a consortium to bid for a site in South Wales. In 2007, the consortium engaged Arup for the provision of services in preparation for the consortium's bid for the site. Then in 2009, the consortium again engaged Arup for the provision of various services at the site. Clause 6.3 of the 2009 contract, so the second contract, sought to limit Arup's liability in contract, tort, including negligence, breach of statutory duty or otherwise, for pollution and contamination to 5 million in the aggregate, and provided that liability for any claim in relation to asbestos is excluded. The consortium commenced proceedings claiming damages for breach of contract and negligence for failing to advise of asbestos at the site, classic issue perhaps. Arup claimed that liability for asbestos was excluded under the 2009 contract. The consortium argued that excluding liability removes Arup's incentive for performing the services properly and disputed whether any claim in relation to asbestos, as stated in the exclusion clause, covered all asbestos-related claims, whether in negligence, contract or otherwise. Fortunately, and definitely the right decision, the court held that clause 6.3 of the contract did exclude all liability relating to asbestos. The court construed the exclusion clause widely and held that it was clear and apt to limit exclude liability, whatever the cause. So this decision clearly highlights that the wording of limitation and exclusion clauses, whilst they should be considered carefully, they can stand up if they are well drafted. Finally, in relation to types of limitation clauses, I want to briefly touch on evaporation clauses. These provide that the consultant's liability is limited to that which is recoverable under its PI policy. An example clause is provided in the AC Agreement 1 at B13 in relation to pollution and contamination risks. The clause provides that liability shall not exceed, in respect of any one claim or series of claims arising out of the same occurrence, that which is recoverable by the consultant under its professional indemnity insurance. This is, in my view, a very effective clause and would provide comfort to the consultant that there'll be no circumstances where it has to reach into its pockets to meet the liability, save, of course, in respect of any excess. My view is that such a clause is now rarely included in appointments, and it's unlikely to be accepted by clients in relation to any breach or in respect of negligence. However, it may be acceptable, and such a clause has a place in relation to specific risks such as pollution and contamination in place of an outright exclusion, as mentioned earlier. So it's a good compromise to have up one's sleeve. Now over to Simi.
Thanks, Will. Now that we've discussed the most common examples of limit of liability clauses and exclusion clauses, in the next section of this webinar, I will be debating the approach to limiting and excluding liability in standard form agreements which consultants are used to entering into, and suggesting improvements to these standard forms. As the most widely used standard form agreement in the UK infrastructure sector, I'll begin with the NEC Professional Services Contract. The NEC 3 PSC includes provision for a limit of liability in clause 82.1. Clause 82.1 provides that the limit on the consultant's liability is to the amount stated in the contract data. Commonly, consultants do not appreciate the importance of ensuring that the contract data is completed accurately, including ensuring that a cap on liability is included. Given the wording in Clause 82.1, if the contract data does not specify an amount of the cap on liability, then liability will be unlimited. It is therefore very important that the contract data is completed accurately. However, the drafting of the limit of liability in Clause 82.1 does not apply to a number of excluded matters. This includes delay damages if applicable, infringement of third-party rights, and loss or damage to third-party property. Losses relating to third-party property could be significant, and this includes a rather large exclusion to the cap. Whilst I have come across some consultants who accept that this is the norm, the amounts payable in respect of these excluded matters will be unlimited and will be payable in addition to any aggregate amount agreed in the contract data. In my view, the preferred position is to therefore ensure that the excluded matters are removed from Clause 82.1 as an amendment to the NEC 3 PSC. In relation to indirect and consequential losses, there is some confusion amongst consultants on whether such losses are excluded under the NEC 3 PSC. Pursuant to option X18, a consultant can limit liability for indirect and consequential losses to an agreed amount to be stated in the contract data. As above, if this option is selected and no amount is selected, liability is unlimited. Crucially, what is important to note is that this is not an exclusion for indirect and consequential losses, but a cap on liability for such losses. The danger here is that by limiting the amount of indirect and consequential losses, consultants are in fact agreeing to be liable for them. Failing to therefore include a limit would mean unlimited liability. My recommendation would be to ensure that the appropriate option X clauses are selected, and if you are looking to exclude liability for indirect or consequential losses, add this as an additional Z clause to the agreement. Turning to net contribution clauses, as Will mentioned earlier, whilst the standard form net contribution clause is included in Clause 82.2 of the NEC 3 PSC, the drafting is brief and without the usual bells and whistles which a standard net contribution clause should contain. Whilst the inclusion of this narrow net contribution clause may be an acceptable starting point, where possible, I would suggest the drafting is amended to reflect the wider wording discussed by Will earlier in this webinar. Turning now to the ACE Agreement 1 for design, this agreement is a crown jewel when it comes to the standard form that incorporates well-drafted limitation clauses. The limitation clauses are included in F7 of the ACE agreement and the particulars. If you have not done so already, I really recommend that you consider this agreement. Starting firstly with limits of liability, Clause F7.1 limits liability for all claims to an aggregate amount. The amount is to be set in the particulars and is the lesser of the sum stated or 10 times the fee payable. If a sum is not specified, then the default position pursuant to Clause B12 is 10 times the fee. As touched upon by Will earlier, there are limits of liability for pollution and contamination claims included in the ACE agreement, which provides that a liability for pollution and contamination shall not exceed, in respect of any one claim or series of claims arising out of the same occurrence, that which is recoverable by the consultant under its professional indemnity insurance. The ACE agreement deals with claims arising out of asbestos and terrorism in the same way. The ACE agreement also includes a net contribution clause and a limit for the time within which claims can be brought. In relation to the net contribution clause, this is widely drafted, amongst other things, by extending the parties within the net who may be jointly liable, such as other advisors, contractors, subcontractors involved on the project. The drafting of the net contribution clause in the ACE agreement is therefore preferred in comparison to other standard forms. The drafting of the limits for the time within which claims can be brought refers to all types of claims, not just those for breach of contract, and applies to the earlier of the time stated in the particulars or prescribed by law. Of the common limits of liability, there is no exclusion for indirect or consequential loss in the ACE agreement. To ensure completeness of the limitation clauses, a standard form exclusion for indirect and consequential losses should therefore be negotiated where appropriate. Whilst another commonly used standard form agreement, especially amongst our architect clients, the drafting of the liability clauses within the REBA 2010 agreement is not as favourable as under the ACE agreement. For instance, the REBA 2010 limitation provisions begin with a limit on the time to bring claims in terms not dissimilar to the ACE agreement. However, there is no express reference to claims in negligence. The clause refers to tort only. As to the limit of liability, this is included in Clause 721 of the REBA 2010 and is limited to the level of insurance which the architect is required to take out. The drafting also does not expressly include actions in negligence. I recommend including express reference to negligence, as by referring to only tort, there is a real possibility that the professional's liability in negligence will be unlimited. The same applies to the time limits clause I just mentioned. This is one of the reasons the ACE agreement drafting is preferred. Furthermore, as the limit of liability is tied to the level of insurance, this is likely to be on an each and every claim basis. As mentioned by Will earlier in this webinar, this will not achieve the aggregate financial limit of liability, which should be preferred. It also needs to be remembered that the consultant's professional indemnity insurance basis could change during the time within which claims can be brought. Rather than putting in the amount of professional indemnity insurance the consultant actually has, and therefore limit the liability to that amount, an appropriate amount for the project should be stated, which could be significantly less. The net contribution clause in REBA 2010 is now narrower than under the REBA agreements, or indeed the ACE agreement. It only refers to consultants and contractors, and there is therefore a danger that some of the other people with whom the consultant could be jointly liable are not brought within this clause. It is therefore preferable to extend this drafting to match the ACE agreement. In terms of other limits and exclusions, the REBA 2010 also includes provision for protecting employees of the consultant from direct claims by the client. This clause does refer specifically to negligence, as well as the defaults or other liabilities, and perhaps reinforces why an express reference to negligence should be included in any limitation clause. There are some less well-known forms, such as the ACE Project Partnering Contract or PPC 2000, often used by our clients. By way of background, the PPC 2000 is a multi-partnering project contract and is adopted for use on a variety of projects in both the public and private sector. In terms of limitation and exclusion clauses, however, the PPC 2000 is lacking, and it goes without saying that as there is no limit of liability nor an exclusion of indirect and consequential loss, this would need to be incorporated into the agreement. In relation to net contribution clauses, there are two options for a net contribution clause in the PPC 2000. The first option, which is demonstrated on the slide, is a net contribution clause on a just and equitable basis, which applies to the partnering team defined in the contract. The partnering team will need to be specified at the outset. The risk here is that the other parties who become involved in the project, which the consultant is not aware of, are excluded from the net contribution clause. It is therefore advisable not to include an exhaustive list of specialists within the definition. The second option is a variant on a net contribution clause and is an attempt to pre-agree responsibility for loss or damage that has not yet arisen. Whilst the first option is a preferred option, it should be amended to reflect all the bells and whistles included in the ACE agreement wording of a net contribution clause, which I mentioned in the earlier slide. And finally, and very briefly on the standard forms, the ACA-ACE Project Alliance Contract 2015 or PPC 2015. The collaborative forms are intended to be suitable for projects of any size designed to support BIM and used under any legal system. Surprisingly, the PPC 2015 does not contain the common limitations and exclusions which we have just discussed and would therefore require a number of special terms to supplement the agreement. This includes, importantly, drafting of a cap on liability. In light of the unlimited liability position and lack of exclusion clauses, the current form may not be attractive to consultants. The approach to limitations and exclusions in the UK market is complex and will generally depend on by who and how the project is procured. In the next few slides, I will consider the market approach to limitation and exclusion clauses and highlight any patterns in relation to the type of project, the clients procuring the projects, and a consultant's place in the hierarchical supply chain. As mentioned by Will, more often than not, liability is limited to a given financial amount on a per claim or an aggregate basis, although there are some circumstances where consultants are forced to sign an appointment with unlimited liability if they wish to be involved in a particular commission. On the majority of projects, the client's form of appointment will be issued to the consultant, usually with an invitation to tender or thereafter for the consultant to accept. These usually do not include limitation and exclusion clauses, and these will need to be negotiated. Where consultants are required to submit a proposal for a particular project, in the absence of terms and conditions proposed by the client, the consultant's proposal will usually incorporate its standard terms, or an industry standard form of appointment such as the ACE agreement or NEC3 PSC, which we discussed earlier. Consultant standard terms and conditions will contain limitation and exclusion clauses. It will also usually include a net contribution clause which seeks to limit liability to that which is just and equitable on the basis of the consultant's responsibility for the loss. We discussed the standard industry appointments previously, and these generally contain limitation and exclusion clauses. In our view, the position in the standard industry appointments in relation to limitation clauses is considered by consultants as a norm or market. In addition to how the project is procured, the approach to limitations and exclusions in the UK consulting market will depend on the client procuring the project. To demonstrate this, it is possible to highlight the typical approaches by the different classes of clients, but of course there will always be exceptions. Turning firstly to the public sector, in our view, it can often be difficult for a consultant to negotiate a limitation and exclusion clause in appointments issued by clients which usually do not include limitation and exclusion clauses. In our view, this is generally because public sector clients now see this as the norm, and also because most public sector appointments are procured pursuant to the restricted procedure and open procedure under the Public Contracts Regulations 2015. These regulations prohibit any material changes to the contract. The regulations apply to tenders by contracting authorities which fall within specified financial thresholds. Where they apply, clients must use certain procurement procedures. For example, where the open or restricted procedure is used, the invitation to tender is likely to be accompanied by a statement that any qualified tender which does not agree to the proposed terms and conditions will automatically make the consultant's bid void. Accordingly, in most cases, any qualified tender which requests limitation and exclusion clauses will either see the amendment rejected or result in the consulting engineer's tender being unsuccessful. Nevertheless, there are exceptions to this position, and in some cases, consultants are able to negotiate contracts even though they are subject to the open or restricted procedure. Where another procedure under the regulations is used, such as the competitive dialogue or negotiated procurements, or the regulations do not apply, of course limits of liability can be negotiated into appointments. This is commonly in the infrastructure sector and where projects are considered high risk. Some protection is offered by the client. In relation to private developer clients, in our experience, the majority of private developers will agree limitation and exclusion clauses, particularly financial limit and liability, as they recognise that consultants give great importance to such clauses. However, this usually depends on who the client is. For example, from our experience, some sophisticated developer clients often insist on no limitation and exclusion clauses. Looking now at the approach taken by contractors, on design and build projects, a number of contractors will agree to limits of liability, especially where the building contract limits the contractor's liability and this is flowed down. For example, option X18 of the NEC3 engineering and construction contract allows for contractor's liability to be limited to a given sum. And another example is clause 2.7 of the JCT design and build contract, which allows for liability to be limited in respect of design. As such, where the contractor adopts a standard form building contract, which incorporates a limit of liability, the consultant may find it easier to negotiate a limitation and exclusion clause in its appointments. Nevertheless, agreeing limitation clauses may be challenging if the building contract does not include any such provisions and the contractor seeks to achieve a back-to-back position. We are aware of some major contractors that are insisting as a matter of policy that limitation clauses are not included in their appointments. Having considered the different approaches to limitation and exclusion clauses in the UK market, in this slide I will look at the trends in the UK market on these clauses. Before the recent recession in 2008, in our view, limits of liability were common. The decreased level of work during the recession meant a more competitive market and consultants often having to accept more onerous appointments, which omitted limitations and exclusions. Despite a significant improvement in the UK market, there is still a hangover of recessionary contracting, particularly in the public sector. Nevertheless, the market has now improved and it continues to do so. Even though limitation and exclusion clauses remain less common than prior to the recession, in most cases, consultants are now able to agree limits of liability more commonly and are generally focusing on improving their risk management measures. Another trend is a move towards including a financial limits of liability, which is linked to the level of professional indemnity insurance required on the project, rather than by the fee. This is perhaps following the Ampleforth case, which I discussed earlier in this webinar. In recent months, we've had a number of requests from our consultant clients on amendments to their standard terms and commercial policies, as well as more consultants telling us they are happy to walk away from projects where liability is not limited. They're also happy to walk away when there is a high project risk. Finally, before handing you back to Will, it is worth also considering how our consultant clients' policies and procedures might approach the risks relating to limitation and exclusion of liability clauses. From my experience, consultants in the UK operate from a starting point where they require the limitation and exclusion clauses which we have just discussed. As much more importance is often being afforded to obtaining a financial limit of liability ahead of, say, an exclusion for indirect or consequential loss, these limits are often discounted. Most consultants in the market will insist as a matter of corporate policy that all commissions include the limitation clauses, and only in special circumstances where the risk profile balanced against the commercial opportunity allows, the consultant will proceed. That said, we are aware of consultants not bidding on projects where they have been unable to achieve limitation clauses and the overall risk profile justifies this. Usually, corporate governance policies and procedures require appointments which do not contain an exclusion for indirect, consequential loss or financial limits of liability clauses to a given minimum to obtain approval from the board, a risk committee, or, say, the general counsel. For example, some consultants have triggers which mean contracts which fail to include a cap on liability or an exclusion for indirect or consequential loss cannot be signed unless they obtain higher approval, whatever the contract sum. A typical approach in relation to financial limits of liability, as in the case of a large international consultant, is a policy dictating that board approval is required where the limit exceeds the lesser of 10 times the fee or 10 million in the aggregate, including unlimited liability. A further approach by another large international consultant is to require any private sector contract with unlimited liability to attend a risk board meeting for approval. However, in relation to engaging with contractors, most of our clients with vigorous corporate policies treat working with contractors very differently to anyone else and commonly require that limitation and exclusion clauses are included in appointments with contractors. When it comes to public sector contracts, often the approach is less stringent, and we are aware that some consultants do not require higher approval in circumstances where there are no caps on liability or the limitation and exclusion clauses Will and I have just discussed. In assessing whether to depart from such corporate governance and provide the required approval to proceed with the project, our clients will undertake the usual commercial risk assessment, having regard to, amongst other things, the client fee, terms, the services, and the consultant's exposure to risk on the project. This will depend largely on a consultant's assessment of the issues and risks involved. I'll now hand you back to Will, who will run through some practical considerations.
Thank you, Simi. I'm wary we've run over, so apologies, and I'll wrap this up as quickly as possible. So that is a summary of the law, what is included in standard forms, market approach, trends, and what you might want to include in your policies and procedures in relation to limits of liability and exclusion clauses. We, Beales, are quite passionate that limits of liability should be included in all appointments where possible. Hopefully a unified approach by consultants can see a further shift in the industry and a more reasonable approach to limits being included in appointment documentation. Unfortunately, in recent years we have seen an increase in appointments containing no limits or unreasonable limits. But let's hope that changes. For what it is worth, and I doubt this will help in negotiations, but in my view, it can be viewed as nonsensical for clients to push for unlimited liability. If everyone or the majority of the market insisted on unlimited liability, it would, as well as creating greater risk to the consultant, increase the client's exposure. Claims could and might increase the number of insolvencies, which would not be to the client's interest in any event. It follows that financial caps on liability create a better chance that claims will be satisfied. In addition, unlimited liability could also increase the cost to clients. As there is more risk to the consultant, arguably this should be priced for in any particular commission. Also, an increase in the value of claims because of, say, unlimited liability could impact insurance premiums, which would also be passed on to clients in the tender price. So whilst this may sound like preaching, financial caps on liability must be to everyone's benefit, at least in theory anyway. That's almost it from me and Simi. We've, as I said, run run over time, and we received quite a few questions, as we always do, and we'll try to respond to these separately after the webinar, if you don't mind. We will also circulate the recording of this webinar and these slides so you and your colleagues can watch at your leisure. Before we do depart, just a quick plug for a Garrick House Network event. It's a seminar and networking event on the 10th of November on the topic of working in uncertain times. Details of the seminar are on the slide in front of you. Amongst other things, the seminar is going to be reporting on a survey we are conducting on the impact of Brexit. It's also going to discuss key risks, challenges and opportunities the industry faces post-Brexit, and we're fortunate to have Andrew Westcott, Head of Policy and Public Affairs at ICE, speaking at the event. Also on the agenda is payment and how our consultant clients, how you can mitigate the risk of late or non-payment. Finally, Stephen Hargreaves from Griffiths & Armour will be speaking on key issues to consider in the planning stage post-Brexit. If you wish to attend, please contact us on the details on the screen. So, sorry for the rush at the end. It remains for me to say thank you for listening to me and Simony this afternoon. I hope the webinar was useful. Please do contact us if you have any queries or questions. Our contact details are on the slide in front of you. Thank you and goodbye.